I'm not the one suffering, my kids are, because I can't do anything extra. I'm literally barely making it.
Exactly where I'm at. I can't afford $60 an hour to see my kids in the closet.
It's not in a closet, it's a new place, and I've told you this before.
I wanted to have the kids, and you took that away from me.
Bianca just
filed, actually pursuant to a previous order about a year ago, where I indicated I would review child support again because I did a significant adjustment under the child support guidelines for Mr. Blair to get resituated upon his release from long-term jail sentence. So that was June or July. We had a hearing June 2nd of 24 and July 25th of 24. Since that time, there has been a modification of parenting time on an emergency basis and an emergency order that was most recently filed by Rule 170.
The next verse. Click legal notice here. Anytime you hear Rule 170 and emergency order, it means something urgent shifted custody or visitation temporarily. Courts don't hand those out lightly usually. They involve allegations about safety, neglect, or serious instability.
On May 14th of 2025, and thereafter, the petitioners advised the court there hasn't been supervised visitation at any particular cost to the respondent exercised. And then I think the motion speaks for itself as far as arrearage and the request for judgment. But Ms. Schooler, there are a couple things that I noted. One is that there is an income withholding order, or was. I don't know if it's still, if he's with the same employer and it's still being withheld, but it provided for a $50 a month arrearage on top of the $750. So $850 if the income withholding orders actually good, should have been being withheld. So there should be, I think you indicated, well, maybe you didn't say that he has not done anything with his arrearage, but you indicated that there's a $7,324.71 arrearage on top of the request for a judgment for medical of $1,472. The other thing is, I hope she has provided to him, although it wasn't attached as an exhibit, those medical bills that would reflect what was owed and that it was paid, and his percentage, which results in the calculation that you've done of $1,472. But I will let you, it's your motion. I do see that you provided also a pay stub for your client of July 9th of 25, which I believe also was produced to reflect the increase in insurance premiums to provide health insurance for the children, which the petitioner is also providing. But I'll let you proceed on your motion, Ms. Schooler.
Thank you, Your Honor. I believe you covered most of it for me. She did, I believe, confer with Mr. Blair on the medical bills. I am working to get copies with her. because she has hit her out of pocket already for the year. She actually hit it already. I think she told me in June. So I believe there has been some conferencing between the two on getting them paid. They haven't been paid, but I will, if we need to delay that for another day, we can, just so I can provide proof for the court. But outside of that, Your Honor, the income withholding order should be withdrawing $800 a month. I believe at our hearing we added on the $50. And he is making consistent payments, which is awesome. The problem is now he's not exercising parenting time, and all costs have fallen onto my client in every way, shape, or form. The $700 he paid, this month only covered school costs. That was it. So because he's not exercising parenting time anymore, it's been a year. We would like to go back to the full obligation with no overall financial condition. And if the court is not willing to enter a judgment today, which I understand I did not attach them as exhibits, I will get the bills. And if we could set a review for 30 days for that specific issue, I can have that to the court for that decision to be made.
Okay. Well, I probably grant the judgment conditional upon you providing proof.
That would be great.
If there's insufficient proof, he can notify the court that he wants the court to reconsider. I don't want to have to come back for a judgment of that amount at this point. But, so, I'm not sure when you answer my question. Is she receiving the child support through an income withholding order?
Yes.
Okay. All right. Now, I made a note back in April, child on the way. That's all I wrote. So I'm assuming Mr. Blair had a child on the way and that child's been born. Is that correct,
Yes.
Mr. Blair?
And there it is a new baby enters the chat. This changes the math completely. In child support cases, any additional kid can recalculate obligations. And here's the kicker, it doesn't erase the old ones. How do you think this should play out? More kids, less per child, or should prior obligations always come first?
That is correct.
So now child support would need to be refigured, I believe, on a different family schedule since he has one additional child to support.
I do believe, yes, I did not include a multiple family adjustment. So I'm not sure if the child had been born yet, and maybe that might have been my mistake. So yes.
When was the child born?
May 27th.
Okay. And are you still with the mother and supporting that child in the home?
Yes, Your Honor.
Okay. And I know she's got some children or something too, but you don't get credit for somebody else's children. Their dad's supposed to pay for them. Whether it happens or not, you don't have a legal obligation to support them, and so it's just not part of the calculations of child support. It's actual children that you're legally obligated to support, not a moral obligation. So I'm not sure how much difference that makes. Mr. Blair, I don't know what to tell you here. I have tried to make your numbers reflect as much consideration as I could possibly give you in this case and make them deduct everything possible. But if they appeal my ruling, it's probably not going to be upheld, frankly, because we're not following the guidelines to the T. And the discretionary adjustments was pretty large, And I'm just afraid that this isn't going to fly long term. So I don't know what to tell you other than at some point your child support is going to have to actually reflect what the guidelines expect in the way of child support, and it's going to have to be adjusted accordingly to withstand any scrutiny on an appeal of it, frankly. And
I just
so
don't.
that's just the truth of it. And I've always encouraged you to get an attorney. And we have some attorneys in this district who will help with child support, or even potentially contacting DCF maybe. But yeah, you haven't had an advocate on your side, and I can't totally advocate for you or collect information on your behalf. But I do believe I've given you considerable latitude and worked very hard to make sure that your child support was minimized. And I'm not 100% sure that's in the best interest of the children. It's certainly not in the best interest of mom. And so I don't know where we go from here, really.
I think it's interesting because I know she had moved into a place that's kind of out of her range, not my choice. I don't believe that she's really been good with her money, and if they're gonna take more out of my check, I won't even have a check at this point. So it just doesn't even make sense. Like, I wouldn't even be able to, if I can't pay for my car and I can't pay for where I live and I can't pay for gas, then I can't do anything.
Well, I understand, and I was hoping you'd get, on your feet. And I'm not trying to be offensive, but you've added another. You already had these four, and you've added another. And I mean, it is tough in this day and age to afford children. And as I've told you before, the guidelines are not based on what mom is or isn't doing with their money, and whether or not you can afford to pay the support or not. They're just not. They're not designed that way.
I don't get how I don't get to see them and I don't get to claim them, but I pay and I haven't missed a single payment.
This is where emotion collides with law. His paying does not seeing the case from his perspective. It feels unfair, but legally, visitation and child support are separate issues. You can't withhold payment just because your DNA visits tenfold too. Absolutely. That's how the law is structured.
None of it makes sense to me, and I haven't done anything to lose my right to see the kids. That was just her choice, and everybody ran with it, and I just sat back and let it happen because I don't feel like I have a choice. I can't afford an attorney.
Your Honor, I understand you have been very gracious in this. For what it's worth, the ability to pay calculation would be $2,956. So we're including the poverty guidelines as well, and that's why it's even lower than it is. It could be almost $3,000.
Well, yeah.
Did you catch that? Even the judge admits it feels like she's advocating for him, and that's a huge red flag. Judges aren't supposed to coach either side. That's when one parent shows up without a lawyer. This awkward imbalance often happens. Imagine trying to argue your case when the other side has a full legal team.
I understand what he's. I understand that he doesn't have a lot of money left over, but I did wish, and my desire is always, I'm sorry, I lost my train of thought there for a second. Part of this process for me is it's very important for parents to get back on track and start paying every month. If you give them an amount that they're going to quit their job, or there's no incentive, or whatever the case may be, then mom ends up with nothing. And the most important thing for mom is to know how much she's getting, and that she gets it every month, and that she can count on it, and that she can budget with it. So that was the starting point really for me in this case, is getting an amount that he had a steady job. He may not totally be back on his feet, but he's working, making an income. She's guaranteed X, and she's been getting X. And I know he hasn't whittled away at the arrearage too much, and now we have this medical. So nobody's really winning here. I just have to figure out how to follow the law, and for it to be as fair as I can make it, with the goal of being him continuing to work, continuing to get raises, hopefully, and to continue to make a specific, consistent amount of money payable to her for the children monthly. So, anyway, that's all I'm going to say about that. But I am going to grant the conditional judgment on the $1,472. I do want to see a worksheet with the multiple child adjustment. And I can't remember, did you give, we've given so much credit that I'm sure it's in there, but the fact that he's not getting to claim the children should be an adjustment for him. And again, I have a philosophy, and I don't think I'm the only judge, that says that if, I order that if there's an arrearage, you'll get an adjustment, but you're not going to get to the full benefit of claiming the children when you have an arrearage. Once you're caught up and once you're paying the guideline amount, then of course you should benefit from claiming the children. So that has historically been my position on that. And so that doesn't mean that forever he'll never get to claim the children, but that has been the order of the court for the time being anyway. So I don't know if you could do another proposed order to me. You can talk to your client. I'm actually more inclined of, instead of increasing the child support amount right now, increasing the arrearage amount in the alternative, so that she's getting that arrearage and he's knocking that arrearage down. And then once that arrearage is close to being paid off, we can take a look again at the child support, or if there is a reason to believe that it meets the 10% threshold or whatever it is of change. Ms. Schooler, what are your objections to that sort of approach?
Your Honor, I've talked with my client prior to filing this motion, and if you look at her DRA, and I'm sure we can all agree living in this economy right now is very expensive. The child support at what it is now is, like I said, just for August, it only covers school expenses. It didn't go to new school clothes, kids are growing, school lunches, getting them ready to go. If it's not August, it's just a normal month. I mean, it's covering some of their health insurance and some of their food, like $300 worth of food for 4 children, which we know probably won't go very far. I can tell you my client is barely surviving at this point, and my client works an excessive amount of hours. I mean, over 60, trying to maintain a job to support these children while having them full-time, 24 hours a day, 7 days a week. And I know typically a lot of time judges will deduct supervised parenting time fees from, child support arrearage, but he's not even doing that either. So her hands are tied. I understand that it's a lot of money for him to front, but that's a lot of money for my client to front, and that's not even all it takes to be a parent. She's raising these children by herself as well. So we would prefer that the child support go up. Like I said, she needs help, but I completely understand your position as well, as it would be probably maybe better for her to have the consistent $800 and we boost it up so it stays consistent money coming in her pocket in case, Mr. Blair loses his job or leaves his employment. She doesn't have that guaranteed money to budget around. It is an unfortunate circumstance, however, for my client. She's working her tail off and barely making ends meet in this economy with 4 children. So I believe, based off of our conversations prior to the hearing, she would prefer child support to go up, and for the judgment, which we've kind of discussed. Bianca, if that's not your position, please let me know real quick. Okay. She nodded yes, Your Honor, so I believe that is. We would prefer, he is already getting also the $360 tax credit. I'm not sure if he's aware that if we take that away and he starts claiming them on taxes, that's another $300 or more going onto his child support obligation a month. I don't know if he's looked into the kids going onto his health insurance. I know that would probably help my client, and it would lower his obligation as well.
And with that, the case is set for a final showdown, October 16th, marked down. This is where the temporary adjustments and solidify into long-term models all flip completely. Twice your best. Will the court favor consistency for one, or leniency for the other? Let's hear your predictions. At the gate, where in the middle of a high-stakes family court drama, notice how both parents start by framing themselves as struggling for the kids, a classic move in custody and support hearings. That who's the court really going to side with? Drop your guess in the comments below.
So it's unfortunate.
I'm sure too he would, again, I can't, it almost feels like sometimes I'm being his attorney and he doesn't have one, and he doesn't have the cost for one, but I'm sure he would take the kids to give her a reprieve financially and mentally and otherwise, but that was taken from him by a motion that she filed, and I understand that she's looking out for her kids and she felt strongly about her motion or she wouldn't have filed it. But I guess sometimes you got to be careful what you wish for, and so I do understand it's a lot. So
I do believe a DCF investigation might have been opened because the children did. This started because the children disclosed this to a therapist. This wasn't even also just my client. The therapist provided this information to her, and I believe DCF. So,
Did not supervise visitation for over 6 months and hasn't done anything by choice. He has not gone. The kids and I went and made sure that, we did everything that we needed to do so he could go in and do his part to see them, and he hasn't. I don't mind having my kids. I love my kids. I fight for them. I do everything I do for them for a reason. And if their safety is not secured at his house, I'm definitely going to fight for my kids to get what they want. I'm not doing it for me. I'm doing it for them. And that's the frustrating part, is I'm I get it. I'm okay with being their single parent. I'm okay with doing everything by myself. But I'm struggling too. My rent went up. They have $700 in school fees I can't pay. They need school supplies and new school clothes I can't buy. I'm barely making my bills as it is. His girlfriend owns her house. She pays a very large majority of the bills, and I know this because he's personally told me he's gotten a raise since the last time we were in court.
Okay.
I've been nice to him, and I don't know what else I'm supposed to do, but I'm not getting anything from it.
Okay.
I'm not the one suffering, my kids are, because I can't do anything extra. I'm literally barely making it.
Okay.